Good morning. Thanks for joining us this morning. I'm Keli Law. This is Simone Brew. We're both principals at Matthews Folbigg Lawyers at Parramatta. Now, we've worked and assisted local government and local councils with their notices and orders and enforcement and compliance issues for over 20 years. So that's something we'd like to talk to you about today. Simone and I often give seminars, and one of the questions we're often asked about is how do we assist councils in drafting effective and valid notices and orders from a compliance and enforcement perspective. So rather than talk to you today about the legislation and the very specifics of each act, because there are so many different acts that deal with enforcement and compliance issues, we'd like you to walk away today with something that we think would be hopefully practical for you to move forward with how to apply and craft valid notices and orders. And that's a checklist that will set out various things you need to think about and consider when drafting those notices and orders. Now, some of the acts that you would generally deal with on a day-to-day basis would be the Environmental Planning and Assessment Act, the Local Government Act, the Protection of the Environment Operations Act, Swimming Pools Act, Companions Animal Act, and the Food Act. Simone, if you could assist Council with the first checklist point.
Sure, thanks Keli. Look, one of the most important things which is overlooked are some of the cornerstone issues in relation to statutory notices and orders. What we find is council officers are very busy. They are forced to put on orders in a very timely manner, either to stop someone from doing something or to make sure that somebody does something. And often some of the essentials are overlooked. And what we hope to achieve today is to give you those essentials and basically the checklist, as Keli said, so that we can make sure that your statutory notices and orders are valid. The first one is in relation to delegations. Now, the problem that we often find is the first thing we do is ask for a copy of a council officer's delegations. Sometimes they'll give us a copy of their card and not the actual delegation. Now, under the Local Government Act, the General Manager has the authority to delegate functions to council officers. The council officers can only act in accordance with the delegation. Councils have often different delegations. For example, they will have a delegation to a particular council officer, or they will have a delegation to a class of council officers. And what we find is sometimes people are promoted and the delegation doesn't follow, or we sometimes find that council officers move sections in the council and the delegation doesn't follow. So it's very important that you check your delegation. It will be in writing, signed by the General Manager, and have a look and see what you actually are allowed to do. So it's very important when an order is issued that all of the investigations that took place were done in accordance with a valid delegation. So for example, if you were going onto a property in relation to a breach of the Environmental Planning and Assessment Act, you need to have investigative delegation with respect to that act. If you also go onto premises, you need to ensure that you comply with the relevant act so that that notice or order will not be valid, as those investigations basically underpinned the issuing of the notice. So if, for example, you want to use force or you want to go into a residential premise, make sure you follow all of the requirements in relation to the act, just to ensure that all of the investigations that underpin that notice make that notice valid. Keli?
Thanks, Simone. And if actually I can add another example there as well. Thanks, Simone. I recently had a matter whereby there was some concern that a landowner was damaging a heritage item. Now, it was a home the landowner was living in. So obviously council's compliance officers wanted to go out and have a look. Now, this is before solicitors became involved in the matter, and understandably they took their heritage officer to have a look because the heritage officer would be best placed to know the significance of the damage that had been done to the home. Now, as it would normally occur, a heritage officer is not a compliance or enforcement officer, so their usual delegations would not allow them to enter onto premises and to take samples or photos, those kinds of investigation measures. So in this particular instance, the relevant council officer had to ensure they had delegation in writing first before they went onto the premises. And so that's, again, something that you may not think about as a council officer if it's not part of your day-to-day job, but you as a compliance officer, if you're going to ask somebody with a certain level of expertise from council to assist you in undertaking those investigations, just check and be mindful as to whether or not they actually have the delegated authority to enter those premises and assist you in that sense as well.
That's a good point.
Thanks, Simone. And if I could go on to the next point, again talking about delegation, is once you've undertaken those investigations, you're probably also going to be the relevant council officer that's going to prepare the notice in a draft form to be signed by somebody. The next thing to think about is, do you actually have the delegation, i.e. do you have written authority to sign the notice and order? As lawyers, once we are given a notice and order to enforce, we will always ask the client to provide us with a copy of the delegation for the person that signed it, so we can satisfy ourselves to that effect. So again, you may not be the person who's going to sign it, and that may very well be because you're aware that you don't have the authority to sign notices and orders, and that will be the kind of wording that will appear in your delegation if you do have that authority. And it may be the case that your manager is the person who has the authority to sign the notices and orders. Again, that's something that's very simple but can be fatal to a valid notice and order. Simone, if you could talk to the audience about the next point.
Yeah, sure. Look, one very important thing, and the next important thing, is who do you issue the order to? Now, there are only really two entities that can actually have orders issued against them. The first is obviously an individual. You can issue it to an individual person, male or female. In relation to a corporation, you can issue it against that as it's a legal entity. We often find orders being issued to business names, and unfortunately a business name is not a legal entity in its own right. Generally speaking, when you do a business name search, which is what should always be done, you will find that there is a corporation or an individual who is actually trading as the business name. Now, those corporations or individuals are the entities that the notice should be served upon and not the business name. Otherwise, the notice will be invalid.
Keli? Thanks, Simone. And if I could just give an example there, and if you don't mind, Simone, I'm going to steal an example that I know you often use when we give this seminar. The business names that you might be common with, Mr. Whippy, Muffin Break, just be mindful that those are business names. They're not corporate entities, and you'll need to do a search of Muffin Break or Mr. Whippy to find what the corporate entity is that owns that business name. So then your notice will be addressed to the corporate entity, let's just say ABC Proprietary Limited, trading as Mr. Whippy, trading as Muffin Break.
You can actually put in the notice trading as if you want to clarify it, and it does help the recipient understand what actual business name the order is directed at, but it must be on a person or the corporation trading as the business name.
Thanks, Simone. And the next thing I'd like to address in terms of things you need to consider when issuing a notice or order is whether or not, and to make sure you've looked at the various sections of the Act which provide for notices and orders and ascertain which best describes what you're trying to achieve. So what I mean when I say that from a practical point of view is, for the EP&A Act, have you looked at Section 121B, the table in 121B, and considered which order is appropriate? So you need to think about, as a council, what remedy you'd like to implement, and that's what needs to be a term in your order. Now, it may be very well the case that you've canvassed all the acts that you would normally consider. You've looked at the Local Government Act, you've looked at the POE, you've looked at the Food Act, and you've looked at the Environmental Planning and Assessment Act, and you can't find a suitable remedy to fix the offence or the breach of the section. Now, in those kinds of circumstances, you can still issue what we commonly refer to as lawyers as a letter of demand. Now, it doesn't have the same enforcement options for council, i.e. if somebody doesn't comply with a letter of demand, you can't issue a PIN or commence criminal proceedings. But it does provide you with the basis upon which you sufficiently provided the recipient of that letter some warning and some understanding is of what orders have been breached or what sections the recipient has failed to comply with, and what council intends to do about it if rectification doesn't occur. Thanks, Simone.
All right, there's one important thing to consider when issuing a notice. It's not very common, however, it's something that councils need to carefully consider. You may render a person homeless, for example, if you serve a 121B order under the EP&A Act. And if you, for example, you may want to order that a building be destroyed. It might be a residential home, and there may be someone living there. If that is the case, whether or not it's an emergency, you really should consider 121G of the EPNA Act. That deals with when a person may be rendered homeless. And what council needs to do before issuing any such notice is making sure that the recipient of the notice has alternate accommodation. Now, all council needs to do is have evidence that they have alternate accommodation. They do not need to provide alternate accommodation for that person. If you cannot get evidence, what you then need to do is perhaps send names of real estate agents to the person, give them details of the local aged care facilities if they are elderly, or contact some social services and find out places that they can contact to try and make sure that they know where they can get some other accommodation from. It's something that we highly recommend, and even in emergency situations, there is a case that says that whilst council does not have to comply with that section, it really should. So we recommend that in all those circumstances they do that.
Yeah, thanks, Simone. That's a great point. Now, if I can move on to the next point, is whether or not you've also considered, is this a circumstance in which a notice of intention needs to be served? You may already be aware that the Protection of the Environment Operation Act does not expressly state anywhere in that Act that you need to serve a notice of intention if, for example, you're issuing a clean-up notice. However, the Environmental Planning and Assessment Act does have express procedures upon which you need to issue a notice of intention, and it clearly sets out what has to be said in that notice of intention and what it needs to advise the recipient of the notice. Now, you can think of a notice of intention as a warning. It's a written warning. The reason why it's really important for council to provide those written warnings to recipients of notice is because council is regarded by the court system as a model litigant. And what underpins that is that council needs to afford recipients of notice procedural fairness and natural justice. And one of the ways in which council does that is by issuing notices of intentions and warning. So let's look at the circumstances in which you might issue a notice of intention under the Protection of the Environment of the Operations Act, even when the legislation doesn't expressly state you need to. The question you need to ask yourself is it an emergency? That is there an immediate risk of harm to the environment? Or, addressing a similar issue under the Environmental Planning and the Assessment Act, is there an immediate risk of injury to property and or persons? Let's look at two examples. An example under the Protection of the Environment Operations Act might be something as simple as a lack of sediment control devices around a construction or a building site. Often when demolition is occurring, there are trucks going into and out of the premises that trail out dirt on their tyres, and just the general nature of the work that's being undertaken on site often leads to dirt being left on the road and the exterior premises outside the subject land. Now, once it rains or there's inclement weather, that dirt turns to mud and can often go down drains and will enter a main body of water, causing and likely to cause a pollution incident, predominantly being water pollution. So council obviously would like that not to occur and to minimise that harm to the environment. Now, it doesn't take much for a recipient of a notice to comply with a term that seeks to implement sediment control devices, whether it be something as simple as perimeter fencing with the hessian included around that perimeter fencing, or sandbags in the drains and or on the road and driveway exiting the premises. That's a simple solution, it's effective, and it's also cost effective as well. So under that kind of circumstance, there is a basis and there is good reasoning for why you should issue don't have to issue a notice of intention. Now, an example of where you would need to issue a notice of intention for a clean-up notice might be if there's a substantial C&D waste left outside a premises or on a premises in circumstances where it shouldn't be. The C&D waste doesn't have an immediate harm to the environment, and you've determined that objectively with some objective evidence. you would then afford that person an opportunity and provide them with a warning by issuing a notice of intention. Now, under the EP&A Act, an example might be you might have a perimeter fencing around a residential block that's clearly in a state of disrepair, and that perimeter fencing is just about to fall down. It's obvious to you that it's about to fall down given its lack of structure or its instability. So you consider that if that structure falls down, it is going to harm pedestrians that are walking right alongside it. So you may consider that a basis upon which to issue an emergency order, of which there's a specific section in the EP&A Act that addresses that, and that will allow you and dispense with the need for you to have to provide a notice of intention. So in short, is there an emergency? Is there an immediate harm to the environment? And is there an immediate risk of injury to persons or property? If there is, that may be a circumstance in which you don't have to issue a notice of intention. Simone?
What we also need to be careful of in relation to notices is whether or not, when you do a notice of intention, are you making it clear that it is actually a warning? There's case law to say that if a recipient of a notice can be confused in relation to whether or not it is just a warning or the actual order, then the notice itself issued after that document will be invalid. So what we often find is councils will include a notice of warning actually in the body of the order, and they will call it a notice of intention, but it also actually looks like an order. To make sure that that does not occur and the recipient is very clear that it is a warning, we recommend that a letter be done and called a notice of intention with the relevant parts of the legislation on that document. And then attached to that should be a draft order, and we think it should be watermark draft, to make it very, very clear to the recipient that it actually is just a warning and that the attached document is the order that will be served should they not comply. Then, when the order is served, the watermark can be removed, and the council needs to make sure that there's no reference to notice of intention whatsoever throughout the whole order. That way, the court will always find that an order will be valid because a clear warning was given. That's the best way, we think, to deal with notice of intentions. Keli?
Thanks, Simone. And if I could just add to that, another really good practical tips, in addition to the great tips Simone's already given you, is to have a covering letter. And that on that covering letter clearly set out that you're giving the person or the recipient of the notice an opportunity to make representations as to time of compliance or some aspect of the terms, or some other reason why they don't think they need to comply with the order, and that if they don't make those written representations within a specified date by a certain time, that the attached order, the accompanying, that is, notice of intention to issue an order, will be issued as what I often call an in-force order. And that's another way to make it really clear to somebody that the attached document is in fact a written warning or a notice of intention. Now, don't make the mistake, I have seen it before, of where the draft watermark is also placed on that covering letter. That doesn't need to be there. We usually put the watermark and recommend that go on the attaching notice of intention to issue an order. If I can next move on to the next point that I'd like to make, is you're at the point now where you've undertaken all those various investigations and considerations, and you're at the point where you're physically drafting the order. So let's look at how that order should look and what it needs to include. Most orders will have a heading that's called reasons for the order. Now, under this section, it's really important these reasons are clear, performance-based, and not simply a repeat of the circumstances of the relevant act. That is, will you be able to point out to some substantive evidence to justify your reasoning if the notice or order is challenged in court? So what I'm saying there is that's a great opportunity for you to include a bit of background and include the dates that you undertook investigations, what the observations were when you undertook those investigations. But what it's paramount there, you don't need to say something, that's not relevant to the Act. It really needs to include facts and circumstances and or evidence that you have that link it back to the section that you're saying is being breached or you're alleging is being breached. For example, if you're issuing a prevention notice or a clean-up notice, you'd probably use the words pollution incident, and you'd include facts and circumstances that set out an evidentiary basis for why you think a pollution incident has occurred. If you're looking at a breach under the EP&A Act, For example, somebody has failed to comply and has undertaken unlawful works, you might set out the relevant environmental planning instrument, and you might set out the relevant sections of 76A as well. So this is the part where you include all those reasons, and again, don't just reiterate what it actually says in the relevant act. The next thing you'll think about when drafting this order is under the heading to do what. Now this is the part where you include your terms and exactly what you'd like the recipient of the notice to do to comply. You can stagger this, so what I mean is you can include varying times for compliance. For example, you may have 6 steps or 6 different types of action that you require the recipient of the notice to complete. The first 3 you may require to be completed within a certain time frame. It may be 5 days, and the next part, say steps after that, may be an extended period. For example, you may be asking them to prepare some kind of report, which often takes time, and you may give them something as large as 60 days. So you can include staggered timeframes in this part, but it's important that the to-do what is clear and concise. And you can think of it often, Simone, you use the example of a contractor's scope of works. And I think that's really practical to set it out as to how you might include a scope of works if you were giving instructions to an external contractor. Then let's have a look at something else you can consider when drafting that notice. Have you placed a time limit on any ongoing requirements? That is, if, for example, something is simple where you're asking somebody to clean up their yard, the grass is overgrown, that kind of situation or factual circumstance, you would ask them to keep their grass kept below at a certain centimetre height, but you need to stipulate a time period in there. I think it's unreasonable, and the courts have found it's unreasonable to stipulate that certain height for no time period at all. You need to include a reasonable time period. Something like 12 months, maybe 2 years is a reasonable time period. Simone, do you think 5 years is an unreasonable time period when you're talking about that kind of circumstance?
I do. I think 5 years is too long. I think the maximum should be, say, for example, 2.5, 3 years.
Yeah.
But no more than that, otherwise the court will probably find it invalid.
Thanks, Simone. Okay, moving on to the next point. Again, we're talking about what you need to include when you're drafting that order. There's always sections that require you to give the recipient of the notice a reasonable period of time for compliance. And people are always asking me, as I'm sure they are you too, Simone, what is a reasonable time period? And we often throw it back to yourself as compliance officers. We will then ask you, well, how long would it take a person to comply with that term? It may be the case that they need to, it wouldn't be unreasonable, for example, for them to employ the services of an external contractor. That may take them some time to engage those persons, and it may also be Christmas. It may be a certain period of time where it's difficult to engage contractors. So you need to take into all those kinds of things into consideration. That is, you need to take in the specific circumstances of the recipient of the notice. Now, Simone's already touched on this, but just to reiterate, if you have already issued a notice of intention and you're now at the point when you're issuing the order, again, when drafting this order, make sure you remove that watermark and you remove any references to it being a draft or a notice of intention. And in this part, it's also important to make sure that you've got your time for compliance, and that we recommend that your time for compliance does not say something generic like within 7 days. There has been some recent cases that have struggled with this term, i.e. what does the word within mean? Now, a layman or recipient of the notice who may not have any legal expertise is going to think within 7 days is a period less than 7 days. But you as a council officer are thinking that it is in fact 7 days, and to not do it, for example, after day number 7 or day number 6, that you would issue a enforcement action or some kind of PIN, whereas the recipient of the notice may not think it's that simple to understand. So we always like to encourage councils to include an exact date with a time frame such as 5 p.m. Now, let's move on to the next step, Simone.
Now, when you're looking at service, each of the different acts has, unfortunately, different provisions. Generally, service on an individual is acceptable. However, if you're ever serving a notice under any of the acts, you need to look at the service section for each particular act, because they do vary and it can be very, very confusing. So a lot of the notice sections also provide for just not notices or statutory notices. They also provide for other documentation that the council may send through to you. So, for example, it also applies to rates notices. So the references in these service provisions actually refer to business, and that is what makes it confusing when people are issuing notices, because they think they can issue it to a business because the actual service section refers to businesses. So what you need to do is ignore those provisions when they say in relation to a business, and simply just look at those provisions that relate to individuals and corporations. Now, one of the acts refers to you can serve it at a place of residence to someone over 14 years of age. Another provides for over 16 years of age. Another doesn't have any age limit at all. So it can be very, very confusing, and we would recommend that each time you serve a notice, just make sure you're serving it in accordance with the actual service provisions. In relation to corporations, generally, you can serve it on the registered office, and that registered office will actually be listed on a company search if you undertake one. Some of the others provide for electronic service, but only in circumstances when the recipient agrees to electronic service. So there have been situations where, for example, somebody's received an email with a notice and that person has responded and advised that they've received the notice. That will not constitute service, even though the person says they accept service and even though the person has actually received the document. So you need to be very careful that it's actually served in accordance with the legislation.
Great, thanks Simone, that's a great tip. And let's just drill down into one of the acts. Let's look at something helpful that often council officers use all the time, the Local Government Act, because I've found that there are quite some nuances in that particular act that it's important to keep into consideration. Now, another great tip is if you are affecting personal service and you obviously have the time and you consider it to be justified, we always recommend hand delivering service of that notice if you're serving it on an individual or on a corporation. And if you're doing that, take a photo of you hand delivering that notice. That's great evidence. Also, under the Local Government Act, specifically I'm looking at section 710 here, you can deliver it, as Simone has already suggested, to where the person lives. And another tip that they've included in the Local Government Act that isn't specifically included in other acts is fixing the notice to any conspicuous part of the land. I've often seen council officers affix a notice to the front door. Be careful obviously not to damage the door, but there's no problem with that as well, and the Act specifically provides you and allows you to do that, so that's a great way to serve things as well. But again, take a photo if you're going to serve things in that way. If you are going to hand deliver, have something written on the notice that you're hand delivering it and the date that you've hand delivered it. Keep a file note of once you've hand delivered it, of when you went there, who you spoke to, what that person says, as that kind of information may need to be included in a statutory declaration or an affidavit or a witness statement at some other point down the track. Now, there's also some provisions that have been introduced into the Acts that allow service by electronic transmission, that is, by email. But it's really important to note, it may be the case that you've already established a business relationship with the recipient of the notice and you have been communicating them with some time about their business and the issues and failures to comply with the Act. So you've already got an email address for them. But it's important to note that even if you do already have an email address for them that you have been communicating with them to date, you need to set in place an arrangement or set in place and make it clear that they will allow you to use that email address for the provision of serving notices. Now, this is a tip and often has happened to us in the past, Simone, so it's something to be really aware of. If you've already got an existing relationship with them, don't just assume that you can then serve any notice on them. Often the case, this often appears where you're serving a notice on a landowner or something like that, and they're no longer living at that residence because the residence has been demolished and works are currently undertaken, or it may be the landowner of a business and they don't live or operate their business, their day-to-day business, from that premises. So the only way you genuinely communicate with them is by email or over the phone. Just make sure you've actually got some kind of written evidence of having that formal arrangement in place as well.
No, they're all really good points, Keli. And really, service is ultimately the most important part of the process. You need to make sure that the document's properly served. Otherwise, you could find yourself down the track in someone perhaps appealing order in court and having to go through the whole process only to find that it wasn't served properly. So it is one of the most important parts of the whole process.
Thanks, Simone. Now, there are a couple of acts that you may deal with on a day-to-day basis that don't talk much and give you much assistance or guidance with how to serve notices and orders. There are provisions in the Swimming Pools Act. You'd have a look at Section 34. There is some talk of a provision and there's some assistance provided in Clause 35 for the Companions Animal Act. That's in the regulations, I should say, for officers who deal with that particular act. But there isn't a helpful provision for service under the Food Act, for example. So our recommendation as lawyers is if there isn't a provision under a particular act that you're dealing with that addresses service and gives you some guidance in the circumstances and methods of service, go back to the basics. So that is, go back to the Interpretations Act. You probably have a look at Section 76, which talks about service by post on an individual. Now, if you have any of your other acts, because some of the other acts, the EP&A Act, use words in the ordinary course of post. And this is the act that actually defines what that means. It means the 4th working day after you've posted. Now, let's keep that in mind, the 4th working day, when you're thinking about your time for compliance. So when you put in what you consider to be a reasonable time for compliance in your notice, give some consideration to the fact that it may not be received by that person that day or the day after, especially given that the recipient of that notice can rely on this section to stipulate that it wasn't served until the 4th working day after you posted it. So just be mindful of that when you're talking about time for compliances. So if you would like a time for compliance that's less than that 4 days, we definitely recommend that you hand deliver the document or put in place as soon as you think there's a breach of an act and you may wish to take some kind of enforcement action by way of issuing a notice in order, put in place some kind of actual written arrangement that the recipient of a potential notice will agree to accept service of that document by email or some kind of electronic transmission. Now, however, if you're going to be serving a document on a corporation, and again, the act that you're dealing with in terms of the breach doesn't set out some helpful ways or gives you some guidance on how to serve it on a corporation, have a look at Section 109X, capital X that is, of the Corporations Act. That will provide you with some assistance in that regard, and it'll also give you some guidance if, for example, a liquidator has been appointed or something similar to that. But I don't wish to complicate that too much by going down to those tracks right now.
The other thing I could add in relation to service by post is that you'll need to prove a general system at council in relation to post. So, for example, we would need to set out in evidence a system that the council has. So it may be there's a basket where the mail goes or the notice is signed, goes into that basket, gets taken to the mail room and then is posted. We would need a system in place to be able to show the court that there is a system for mail that's sent by post. And this can sometimes be very difficult, although as long as there is a system and we are able to prove that, it means that it will be valid service in relation to postage.
Thanks, Simone. And that's a great point. I'm glad you've raised it because some councils we've actually found they have a register. I don't know whether you've come across that before, Simone, but they have a register where they record documents that are being posted, and we will often ask councils if they do keep a register of documents that are being sent out by post, and we'll ask them to provide us with a copy of that, and we can include that. We've had matters that have been prepared by council officers with great due diligence, great care and attention, but then they've simply put the notice signed it by the proper person into a tray, and don't have any real knowledge or understanding of how it then actually gets to the person. Again, which is why my favourite recommendation, if it's obviously possible, is to hand deliver any of these notices. And you'd agree with that, wouldn't you, Simone?
I do. I think a register of notices and orders is a really good idea, and it's something that a lot of councils are now starting to do. So that would be our recommendation, wouldn't it, Kelly?
That's great, Simone. I can see that we've got some questions here. And just to let all the audience members know, this is an opportunity now for you to ask some questions. So if you've got some questions, please feel free. And Simone and I will try and get through as many as we can this morning. But if we don't get through all of your questions this morning, we will provide you with a response in due course. Now, I've got a question here. I think it's from Michael. The question is, should the council vary or revoke or reissue a clean-up notice that's been issued under the Protection of the Environment Operations Act to extend the compliance date after the time for compliance has passed? So what I understand that question to ask, Simone, and I'd be helpful for any input that you may wish to add, is you've got a clean-up notice, you've stipulated a specific date that you require compliance with that clean-up notice. That date for compliance has passed, and for whatever reasons, you'd like to extend that date. It may be the case that you've been communicating with the recipient of the notice and they've asked for some more time. May also be due to inclement weather, like you as a objective, reasonable person know that due to rain conditions they've not been able to undertake the works that you've required to them in the notice, and you think it's reasonable to give them an extension. So the question here is that a circumstance in which you can vary or revoke or reissue the notice? And the answer to that question is, I think it is. I think there's some sections in the POE, off the top of my head, and please feel free to correct me if I'm wrong, but I think it's around 319, Simone. Does that sound right to you?
Sounds right.
Yeah, thanks. That allow you the opportunity to vary a notice, and that's because a notice continues and you still have to comply with it, even if the date for compliance has passed. So I would think that's actually a great basis upon which to vary the notice. I don't think you actually need to go to the extent of revoking the notice. If all you're talking about is just the date for compliance, I don't think you need to revoke it. In fact, there's actually some case law that talks about if the only thing you're doing is varying the date for compliance and otherwise the notice stays the same in terms of its terms and or reasons, then it actually is confusing to the recipient of the notice as to which notice applies. So in that circumstance, it's actually easier to just make it quite clear that you're modifying the notice just to the extension of time and to provide them with a copy of that modifying the notice. There is probably an exception to that if there is quite a time difference, a substantial time difference between when you first issued the notice and then you were going to issue the same notice but for the date for compliance. So, for example, do you think 3, 6 months, something like that, Simone?
I think that's fine.
Yeah, and if that's occurred, if 6 months has passed since you issued the notice and you're going to reissue another notice but just change the date for compliance, we would recommend revoking that initial notice and reissuing the notice, because there has been a significant period and you also don't want to run the risk that a court and or a recipient of the notice, if challenged, may submit the argument that council didn't consider there was any environmental harm because it's taken council a substantial amount of time to take any further enforcement action. So in those circumstances, I'd probably recommend revoking the notice. Now, the next question to ask, sorry, I've got this little iPad down here that gives me all these great questions and I'm just getting familiar with it. The next question is, again, we're talking about clean-up notices, so thanks, Michael. In the event the clean-up notice is revoked, should the associated administrative fee also be revoked? That's a great question because people often don't think about what you do with that administration fee, and that's often something that is forgotten. Now, there are sections in the Protection of the Environment Operations Act that allow council to issue administration fee, but it's based upon the underpinning assumption that it's issued as a consequence of a valid clean-up notice. Now, those words valid I don't think are actually included in the section. I think it's about section 94 off the top of my head, but again, I might be wrong, is that it's important that the notice is a valid notice. Now, if you have revoked the notice, you really should revoke that administration fee, and you shouldn't take any enforcement action. For example, you shouldn't issue a penalty infringement notice if that administration fee is not paid unless the notice itself is valid. And the next question, we're still talking about compliance dates with clean-up notices, I think, Simone. So do you mind if I just deal with this question as well? Thanks. Okay, so again, we're talking about this date for compliance, and again, it's from Michael. Must an agreed extension to the compliance date be by way of a varied or a new notice, or is it sufficient enough for the officer to be able to demonstrate written correspondence granting this extension? Now, I'm just thinking about that. So what I envisage, what the question is trying to ascertain is if you've been communicating with a recipient of the notice and you've already agreed to an extension, can you just verbally say to them, yes, that's fine, you can have that extension, no dramas? Well, my answer to that question would be no. And let's go back to what we were talking about probably in the first question when we were talking about clean-up notices, is you should issue a modified notice with a variation of the date for compliance. By all means, attach it to an email if you've got those arrangements already in place, where in your email you may just say, yes, we agree to the extension, and we enclose a modified notice to that effect. So you can definitely make those arrangements and reach that agreement for an extension verbally or in an email, but you should also follow that up with a modified notice as well. And let's go to the next question. I'm just waiting for that screen to come up. Great. Okay, it's a couple of sentences, so let's just read this out. If an officer determines non-compliance with the clean-up notice, should they leave that notice in place with the stipulated compliance date and in a letter confirming actions taken, highlighting the offender's continuing obligation to comply with the clean-up notice, in addition to indicating when the council's next inspection will be, or should the subject notice be varied, stipulating a new compliance date after which council will inspect? There's a couple of things that have come up there, so let me just think about that for a moment. What I'm thinking, or what I'm considering that Michael is asking, is if you've got a clean-up notice and the person's failed to comply with the clean-up notice, or they may have just complied with certain parts of the clean-up notice if it's got different stages in it, what do you do and how do you give them fair warning about their continuing obligation? Because that's a separate offence as well. Now, my first thought is probably that I would, if you're going to issue a PIN, if it's something you'd like to take that enforcement action, issue a PIN for failure to comply with the initial notice, obviously assuming the date for compliance has passed and you've undertaken the inspection to ensure they haven't complied. And maybe a helpful way of taking the next step is when you serve that PIN in the covering letter or in a separate letter sent at the same time, you can let them know about their continuing obligations to comply, and that each day they don't comply, that actually can be a separate offence. And that lays the great foundation, I should say, if you're then going to take some kind of action such as a court attendance notice or some other proceedings in the Land and Environment Court, to seek a continuing penalty, which can be worked out on a daily basis from that court. So I hope that answers the next question. Now, again, we've got a bit of a break, but I am getting an indication from the people behind the screen that there are some more questions. So I'll just wait a moment just for that to pop up. Oh, there it is. So we've got a question. This is from Sue. Now, I feel like I've spoken far too much, so I'm going to let Simone have an opportunity to speak. Simone, so if I could address this question to you.
Sure.
Okay, I'll read it out, given that I've got the device close to me. The question is, can council issue a clean-up notice to an owner's corporation or body corporate associated with multi-unit housing, I suppose something like a residential flat building?
Okay, that's a really, really good question. We have quite a number of problems for some of our council clients in relation to, for example, mattresses and dumping outside of units. And I have investigated this for them before. Under I think it's the Strata Schemes Management Act, and sorry, I'd have to just check which section, I don't know off the top of my head. The owners of a strata are former body corporate, and they could be considered an owner for the purposes of the Protection of the Environment Operations Act in relation to clean-up notices. The only problem is you need to still prove the same elements as if it was just a normal pollution incident with a corporation or an individual. And generally you don't know who has been undertaking the dumping. So it can be dangerous to actually serve such a notice on a body corporate without the evidence and all of the elements that you need proof with in relation to a clean-up notice. So yeah, unless you've got the evidence, I would recommend against it. But the technical answer is yes, you actually can issue it against a body corporate.
Thanks, Sue. That's a great question. Okay, we've got a question that flows out of a similar vein asked by Sam. And that question, I'll just read it out, is what is the initial approach to satisfy the procedural fairness issues when issuing a clean-up notice to a body corporate or owners corporation? Simone?
So that's procedural fairness for a body corporate?
That's correct.
Okay, well, it would be the same procedural fairness in relation to any other clean-up notice. I mean, the procedural fairness needs to be looked at in context of all of the facts and circumstances in relation to your particular matter. There's a leading case of Liverpool Council and Gauchi. I think most people have heard of that case, where in the legislation there is no requirement for a notice of intention at all. And what the court found there is in the circumstances where a clean-up notice was actually issued to the owners of the premises, it was going to cost them hundreds of thousands of dollars to remove asbestos. No notice of intention was given because none was required under the legislation. And what the court found was, it was quite extreme, that the council should have actually given them notice, that the council should have investigated how long it was going to take them to actually afford to be able to clean everything up. Maybe look at the housing market and work out how long it would take for them to actually sell their home if they had to. And they should have made all of those inquiries and liaised or at least given notice of intention back at the time, way before the actual notice was issued. And the court actually found that that notice to be invalid, which was quite a leading case in the area because now everybody has to look at their own facts and circumstances. You have to look at differing things like how much is it going to cost to clean up? How long will it take them to clean up? So, for example, a body corporate, it depends on the actual damage. Do you agree?
Yes, mate.
So if there were like 5 mattresses, well, you could give them 7 days. But if there was an asbestos problem, you have to look at how long would it take them to get an expert out there to have a look. How long would it take them to get somebody to actually clean it up? And you need to give them a reasonable time. And we now always recommend a notice of intention before a clean-up notice unless there's an emergency or a threat to life or danger to life.
We've got another question from the same audience member, again talking about this strata situation. So again, I'll direct that to you again, Simone, if that's okay.
Sure.
What is the legal description for a body corporate or owners corporation that a clean-up notice should be issued to, and the method of service of such a notice on a body corporate or owners corporation? Great question.
Yeah, it is a good question. Basically, in the Strata Schemes Management Act, there's another section for service, and I don't know that off the top of my head, but that sets out, similarly to the other acts, all of the ways of service. And I know it includes executive, the actual body corporate itself, and that's how it gets served, basically in accordance with that same act.
Great. That's a great reference point, Simone. I don't think we've got any other questions, but just to talk a little bit more about notices and orders, and just to go through a run-through of everything that we've said today, that might be helpful, Simone.
I think so.
Again, make sure you've ticked your boxes in relation to delegation. Do you have the delegation to carry out the investigations that you're carrying out? And if you don't, it shouldn't be too hard to get something in place before you do that. And please feel free to call us if you've got a question about that arising out of today. Do you have, or does the person who's signing the notice and order have the delegation to issue the notice and order? Do you need to consider whether or not a notice of intention needs to be issued? Is there an emergency? For example, is there an immediate risk of harm to the environment or an immediate risk of injury to property and or persons? Have you considered if the terms of the order is going to render somebody homeless? Have you looked at the actual section that has been breached or that the recipient of the notice is not complied with, and considered what remedy or action you'd like them to undertake, and made sure there's a provision within one of your relevant acts that allow you to implement and seek that remedy? And have you actually drafted your order appropriately? And what kind of things would you look at when drafting your order? Again, just to summarise on what we've talked about today, Simone.
Oh, just basically making sure you've got a legal entity that it's addressed to, making sure that it's properly structured, making sure, I think you've already discussed the notice of intention, actually is just a warning and a very clear warning, and making sure the terms of the order are incredibly clear, making sure that, in effect, you can sometimes keep them quite simple. So, for example, if you want someone to remove a roof, you can say remove a roof. However, if you want someone to do something more technical, you really need to make it more detailed and structured, as if you were giving it to a subcontractor to undertake the works. We find that's the best way and to keep them valid.
Yep, that's great, Simone. Making sure they've got a reasonable period of time and that you've considered their individual circumstances as to what that reasonable period of time might be, and you've included that in your notice, that your reasons are not just a rehash of what it says in the actual section, and you've used that as an opportunity to include some of the facts and circumstances that relate directly back to the words that are being used in the section of the Act that are being breached. And don't forget, most important of all, and can always be fatal, the service and the method of service you're implementing. And before you serve a document, before you put it in that basket, consider what council's system is, for procedure of documents and services of notice, and that you've gone and had a look at the various sections that deal with services and notices in the particular Act that's being breached. Any other tips on services of notices, Simone?
No, I think we've pretty well covered service. It's just very, very important, because it's the thing that we find most gets people unstuck, is not validly serving it in accordance with the legislation, because each particular piece of legislation is very, very confusing. My biggest tip is always, if you're looking for something in relation to an Act, simply download the whole title of the Act so that you have it word for word. You can then keyword search for example, the word service. You'll find that you can find a lot of information by doing that and not relying on precedents, because legislation changes regularly, and sometimes you'll find yourself in a situation where you may have issued an order, or you've got a precedent you've used previously and a section has changed. That will invalidate your order. So we always recommend pulling up the legislation, keyword searching, and just making sure that there's been no amendments since you last issued a notice. Make sure council has a register of notices. We find that helpful. But that's in a perfect world. We know sometimes that's not always able to be maintained.
Okay, great. We've got a question from Mohammed. Thanks, Mohammed. I'll just read that out. When issuing a penalty notice for a breach of an order, and the order was sent to a corporation, how do you process the penalty or brief to a court? Is it issued to the director of the company, in care of the company, or is it addressed to the company itself? That's a really great question, and I would think have a lot of practical purpose for all of our audience today. I think it needs to be addressed to the corporation.
It does.
Unless you actually, and correct me if I'm wrong, Simone, you may have a view, unless you actually have evidence that the director itself was somehow responsible for committing the offence and the director played a role in committing the offence, you could issue it to the director personally and have the director's name issued on the PIN or on the order, for example. But otherwise, if those circumstances don't apply, just to the legal entity. So just to, for example, ABC Proprietary Limited. What's your thought on that, Simone?
Oh, could I just add, if the question is, can you actually issue the order to a corporation and thereafter issue the PIN to a director, the answer to that is no. You have to issue the PIN on whoever the order was issued to. So I'm just clarifying, I'm not quite sure where that was directed, but if that's the case, it's definitely issue the PIN to whoever the order was issued to. If you're talking about who do you issue the order to and thereafter the PIN, we would recommend the corporation in most circumstances, unless you can find something relevant. There's some provisions in the Protection of the Environment Operations Act that provide for offences against directors, but you'd have to have good evidence that the director had committed the offence before you'd take any action, because the Corporations Act provides quite a big corporate veil over directors to protect them, so there'd have to be specific evidence.
Okay, we've got time for one more question. Thanks, Craig. Again, another great question. Do you consider it necessary to serve orders by way of registered post? Again, the first thing to do is go back to your service provisions under the relevant act, assuming it provides for that method of service. There's nothing wrong or prejudice to council serving things by way of registered post. And if you're going to do that, I would take a photo of the envelope with the registered post sticker on it, or a photo of the envelope that you've written on, and take a file note or prepare a file note or a statement of that you have personally filled in that registered post, that you've then delivered it to the post office, and I think that will even further enhance your evidence in terms of registered post, because the person who's got to receive that notice actually gets a card in the mail, for those of you who don't know, that they need to attend their local post office to pick up that notice, and then that is a mechanism upon which you can ensure that they've received the notice. Do you have anything further to add on that issue, Simone?
No, only just to add that most of the service provisions in the legislation provide for prepay post, which isn't registered post. It's prepay post, but registered post is a good idea.
And there's nothing wrong with that. Sometimes I have found that people know or have some kind of inkling that they're going to be served with something, so they elect not to attend the post office and collect that mail. So although it's a great idea, it doesn't always work, especially where the person has some understanding or expects that they're going to be receiving something like that in the mail, and they simply choose not to attend the post office to collect. Well, I think that's all we've got time for today. It's been great being with you here this morning. Thanks so much for your time. We've really enjoyed it. Simone?
Yeah, thank you very much. We hope you enjoyed it and got something out of the presentation.
Thanks a lot.